Okay, this is Common Doctrines in Civil Law with case examples. This is now part 2. Okay, let's start with the doctrine of forum shopping. Okay, the doctrine of forum shopping means a litigant should not pursue multiple cases simultaneously in different courts for the same issue. An example to this is the case of Benguet Electric Cooperative Incorporated versus National Labor Relations Commission, 1996 case, whereby the court emphasized that filing multiple cases on the same issue constitute forum shopping and is prohibited. Doctrine of piercing the corporate veil. It means when a corporation is used to perpetuate fraud or evade obligations, the court may disregard its separate legal personality, such as in the case of Francisco Motors Corporation versus Court of Appeals, a 1997 case. The court pierced the corporate veil to hold the individual behind the corporation accountable for the corporation's liabilities. Doctrine of vested rights. It means that once rights are vested, they cannot be impaired or taken away without due process of law. Example, in the case of Republic versus CA, 1992 case, the court ruled that vested rights acquired under existing laws cannot be taken away by subsequent legislation. Doctrine of separation of powers. It means that the powers of the government are divided into 3 branches. These are the executive, legislative, and judicial. And each branch is distinct and independent in terms of powers and responsibilities. So for example, in the case of Angara versus Electoral Commission, a 1936 case, the Supreme Court upheld the separation of powers by ruling that the judiciary cannot interfere with the legislative process. Doctrine of pari delicto. It means that when both parties are equally at fault, the law leaves them as they are and denies recovery to either of them. So in the case of spouses Mendoza versus spouses Gomez, a 2010 case, the court applied the doctrine of pari delicto, and in doing so, the court denied recovery to both parties who are equally at fault. Doctrine of unjust enrichment. Okay, this doctrine means that no person shall be allowed to enrich themselves at the expense of another without just cause or compensation. So in the case of Ibasco Services Incorporated versus NLRC, 1992 case, the court held that an employer cannot unjustly enrich itself by taking advantage of the employee's services without proper compensation. Then we have the doctrine of reformation of instruments. In this doctrine, it states that when a written contract does not express the true intention of the parties due to fraud, mutual mistake, or inequitable conduct, it may be reformed to reflect the true intention. So, example, in the case of Felipe versus heirs of Aldon in 2014, the court allowed the reformation of a deed of sale in order to reflect the true agreement of the parties due to a mutual mistake. We have the doctrine of exhaustion of administrative remedies. Okay, this means that before a party can seek judicial intervention, they must first exhaust all available administrative remedies. So, for example, in the case of Angtibay versus Court of Industrial Relations, 1940, the court emphasized that the necessity of exhausting administrative remedies before resorting to the courts. We also have the doctrine of subrogation. In this doctrine, it means that when a person pays a debt for which another is primarily responsible, the payer is subrogated to the rights of the creditor. So for example, in the case of Fortune Insurance versus Court of Appeals 1998, the insurance company, after paying the claim, was subrogated to the rights of the insured against the third party responsible for the loss. We have the doctrine of quantum meruet. It means when a person provides services or materials in the absence of a contract, they are entitled to reasonable compensation. So in the case of Philippine Shell Petroleum Corporation versus CA 1992, the court awarded reasonable compensation to a party who provided services and materials without a formal contract and was just based on the principle of quantum meruet. We have the doctrine of force majeure. Okay, in these doctrines, parties are not liable for damages arising from an unforeseen and uncontrollable event that prevents them from fulfilling their contractual obligations. So for example, in the case of Coppel versus CA 1997, the party excused a party's non-performance due to an unforeseen and unavoidable circumstance. We also have the doctrine of in pari delicto. This means that when parties are equally at fault in a transaction, neither of them can seek legal relief from the other. So in the case of spouses Mendoza versus spouses Gomez, 2010, the court ruled that both parties being at fault precluded recovery by either party. We also have the doctrine of prejudice. This means that a legal action must be based on actual harm or injury suffered by the complainant. So in the case of Philippine Commercial International Bank versus Court of Appeals in 1985, the court ruled that a claim must demonstrate actual prejudice in order to be actionable. We also have the doctrine of equal protection. This means that all persons should be treated equally under similar conditions and circumstances. So in the case of Dorado versus Court of Appeals, 2001, the court upheld that all individuals must be equally protected by the law. We also have the doctrine of contractual freedom, which means that parties are free to enter into contracts and determine their terms as long as they do not contravene public policy or law. Thus, in the case of Philippine National Bank versus Court of Appeals in 2001, the court upheld the freedom of parties to agree on terms so long as these are within the bounds of the law. We also have the doctrine of necessity. In this doctrine, an act that is ordinarily unlawful may be justified if done out of necessity to prevent a greater harm. So in the case of People versus Sharon in 1992, the court justified an act of necessity that prevented greater harm. We also have the doctrine of supremacy of law. This means that the Constitution is the supreme law of the land, and thereby all laws and governmental actions must comply with it. So in the case of Panganiban versus Ocampo, 1986, the court emphasized that all laws and actions must align with the constitutional provisions. We also have the doctrine of fiduciary duty. This means that a party in a position of trust must act in the best interest of another party, often in a relationship of trust or confidence. So in the case of Santos versus Santos in 2005, the court held that a fiduciary must act in good faith and in the best interest of the beneficiary. Doctrine of solemnization. This means that certain acts, such as marriage, must be conducted with specific formalities and procedures in order to be valid. So in the case of People versus Santos 2008, the court emphasized the necessity of formalities in solemnizing marriage. Doctrine of prohibition against unlawful acts. This means that acts that are explicitly prohibited by law are considered unlawful and cannot be validated by agreement or acquiescence. So in the case of Gamboa versus Court of Appeals 1994, the court ruled that actions prohibited by law are invalid regardless of any agreements to the contrary. So that's it. Doctrines in civil law. If you want more videos like this, please don't forget to like, share, and subscribe. I hope you learned something, and thank you very much.